an attorney?
Absolutely.
Well, and I'd suggest that you do that as soon as possible. If they need more time, then certainly the court would entertain a motion to adjourn the trial date. But otherwise, as the posture of this case sits right now,
Okay.
Don't interrupt me. We're going to have a way to you know what? Tell you something, Mr. Montgomery. No, you'll hear me. I'm going to tell you right now, I expect people to conduct themselves in certain ways in my courtroom. I don't know. Just listen to me. I don't want this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever, you can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something, what comes out of your mouth, because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
Yes, Your Honor.
Well, you know, Your Honor, I've always tried to be fair with my tenants, and although I'm not going to stand here and bash him the way he's been bashing me, it is not subpar. I have not raised the rent arbitrarily.
Okay.
We have put out newsletters as to when the rent was raised properly, the way we always have. He can sit there and say we haven't, and yes, I did put out an eviction prior to this one. I tried to work with them, but could you please stop? This is why I really just don't feel like I should work with them.
Just a minute. Mr. DeMayo?
Yes, Your Honor.
Sit down and pay attention. You're in a court proceeding. Don't get up and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street. They allege your kids are dancing on the roof. They're breaking windows out. There are other allegations that have led them to terminate the tenancy. You haven't paid the rent since September and you're full of indignant disgust.
Well, by the 28th, our system will have already charged up May rent. It charges it.
Well, you can't do that.
But
what was their balance on the 28th?
On the 28th, they owed $1,705.50.
And they paid how much on the 28th?
$1,542.50 plus 400. $1,942.50.
So they paid the balance on the 28th in April. Why am I here on this case and there's not a dismissal, counsel? And why was it represented to the court on the 28th before Judge Barr that they owed May rent when May had not accrued?
I can't speak to.
I'd like an answer.
I can't speak what happened on the 20th, but like I said, it sounds like if their system would have put May's rent in the next day, that is probably where that number came from that the attorney was relying upon. I'm looking at a ledger before me, Your Honor, and that's the information I'm giving to the court. And I don't see this payment. So on April 28th. I'm sorry for the confusion this caused. But
I'm not causing it. It's not confusion. There are certain things that have been represented to the court.
Right.
What I'm hearing is that they paid their rent for April and paid it in April.
If the court would like to pass on this matter, I will speak to my client right now. And if it was paid.
Well, I think you better.
Yes.
Court to pass it.
And I have a lot of respect for defense counsel and the way he approaches things, as well as Your Honor. But what defense counsel just said sets a very, very, very dangerous precedent. That now we're talking about things that, if allowed, people would just go about their business and defy what in fact they need to do to lawfully, in this matter, get on the roadway. And I think there are plenty of people that do the right thing just based on the law in order to acquire the means in order to have the privilege to drive. So I think Your Honor got it right in terms of this. I don't disagree with the fact that there are socioeconomic issues that may play a part, but in this particular matter, this defendant had over 3 years with multiple notices in an attempt to try to get, acquire, and pay for what he needed in order to lawfully be on the roadway. And Your Honor, I'm going to leave it with that because I know Your Honor wants to move on to other cases and things, but I do have to say the argument that was just made, potentially people listening to this may say to themselves, hey, we can get out on a personal bond if we don't do things the right way because of the argument that was just made.
People get out on personal bonds every single day for driving with a suspended license every day. In fact, it's court policy that they get out on a personal bond.
But
It is
They kept me the first time I came.
Well, hold it. So when you found out from your probation officer, then you knew I told you to go to jail. Why'd you file an online bench warrant recall?
I don't know if it worked.
Okay, well, that's an honest answer. Then you came to the jail on April 22nd.
And then I told them I had a bench warrant the whole 9 yards. I got there at 7:45 in the morning. I stayed to 10:30. And then they came and told me, you can leave if you want to. You stay or you can leave. That's all they told me. So
They told you you could stay or leave because there was a bench warrant out.
Yes, exactly.
Okay. And so if that was the case, then did you go back?
Yeah, I let me come and came back again.
When did you go back?
I went back the next day.
Why'd you go back the next day if they told you you could leave?
Because something didn't sound right. For them to send me, I can stay or leave.
Okay, so something between the time you left and the time you came back, something just didn't sound right.
No, it didn't seem right. I'm trying to.
Yeah, so you went back.
Yeah.
Yeah, that might have been because they told you not to leave.
No, they didn't tell me to leave, Your Honor.
Oh, okay. All right.
They didn't tell me. They told me that I could stay or leave. They really did. So I left.
Yeah. Sheriff's Department always does that. In face of a bench warrant, they just tell you to leave. All right. Mr. Feaster, anything else you want to add to what your client has indicated?
Not at all.
You know.
So it's safe to say that you had just gotten in your car after having a conversation with the cashier from getting your cigarettes, correct?
No.
Okay. Let's take it a step further then. You get in your car, and yet not only do we know you don't call law enforcement or
I'm
the ambulance.
confused. Your Honor, I'm confused. He's not doing the right order.
Excuse me, sir.
I'm sorry. I'm
Sir?
confused.
Just one moment. Ladies and gentlemen, if I could have you all step outside just for a moment. Mr. Loomer, I'm going to explain something to you, and I want you to listen to me very carefully and internalize what I'm saying. The state asks you questions. You answer their questions, correct?
Correct.
The defense is asking you questions. You need to answer the questions that's being asked of you. The defense attorney can ask his questions however he wants to ask them, and he can ask them in whatever order he wants to ask them. Do you understand?
Yes, ma'am.
So there is not to be the back and forth with me
Yes, ma'am.
where you're telling me, well, Judge, he's asking the questions in a different order. He may ask whatever questions he wants to ask. If there is an issue with the question, then the state may or may not choose to object if it's a question that's objectionable or against the rules. Do you understand?
Yes, ma'am.
So there is to be no comment with me
Yes, ma'am.
about how you feel the defense is asking their questions. Do you understand?
Yes, ma'am.
Is there anything that you do not understand?
No, ma'am.
All right.
Okay, Mr. Loomer, let me just ask you one simple question, and I want you to be honest to the jury, okay? Are you telling this jury that you just do not remember anything that happened?
No, I'm not.
Okay, but some parts are a blur
Yes.
and some parts are not.
Yes.
Okay. When you meet with Detective De La Rosa a second time on March 30th, 2022, okay? I submit to you that Detective De La Rosa had just met with the individual who you claim went into your house and burglarized you, okay? Do you recall Officer De La Rosa telling you your story is not true?
Objection, you're saying?
That'll be overruled.
You can answer the question.
I'm sorry. I'm sorry. Yet, repeat the question, please.
Do you remember Officer De La Rosa, Detective De La Rosa, meeting with you for a second time on March 30th, 2022, and telling you, Mr. Loomer, your story is not consistent?
Yes,
Do you remember truthful?
yes.
You remember telling you, Mr. Loomer, let's start with that. That's when you finally, again, tell Detective De La Rosa that you picked up this individual the night before, March 29th, 2022.
I'm sorry. I gotta take a break. I feel like I'm gonna pass out.
All right, ladies and gentlemen, I'm going to give you a brief recess. You've heard some evidence in this case. Do not have any other pending matters other than this?
I don't believe so, Judge. I think Hank confirmed that the marijuana misdemeanor was not filed.
All right. So, Mr. Contreras, I'm being told that the state is going to file a dismissal in your case. And if they file it, I will sign the dismissal.
Because frankly, it doesn't sound like payments coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's not, no, it's not going to happen. It's not going to. You want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor, that wasn't my attempt.
Is denied. If you can get some legal help, you can try to rebring it. But you didn't even, you just filed a bunch of paperwork. There's no pleading. You didn't file a motion to set aside the default. You just sent me a bunch of stuff. And Mr. Thorne and I couldn't even discern what it is. Now, you're not a lawyer.
No,
so
what I wrote on the paper to you, basically what I wrote, it wasn't.
Stop. If you interrupt me one more time, I'm going to make you go wait out in the parking lot and I'll shout out to you.
I am. And I'm also aware that there are 9 charges pending. Just so that we get all that on the record.
I couldn't hear you, excuse me?
So I'm aware of everything that you just said, but also would just add that there are 9 charges that are currently pending.
Okay,
So they're trying to work through to get them all together. I don't want to talk, Mr. Davis. I don't want to talk about the charges because anything you say could be used against you. So I'm not going to have that conversation with you.
Okay, because they told me
your counsel has indicated that he is trying to do a global resolution for you, which at least on the face of it, from what I'm looking at, makes sense.
So I'm going to
So, okay. And again, Mr. Davis, I'm not arguing with you.
No, because the gentleman yesterday said I was going to mental health court.
No. Well, the gentleman yesterday is the same person that's here. I don't know what happened.
So I'm not going to mental health.
I've known Mr. Gaddy a long time and he doesn't change forms.
Your Honor, I did reach out to Ms. Landy yesterday and she and I had a brief discussion about the case, but we need some additional time to continue to discuss a possible resolution. So I would ask to adjourn the probable cause conference, but I would ask to address bond as well.
Ms. Landy, is that correct? Were you talking to Ms. Noveski or was
it was somebody else? I am a shapeshifter.
Morphing public defenders.
It was, I believe, Ms. Noveski. We did not speak live, but I do believe
I'm just checking.
I do believe it was her.
I mean, they talk to people and change. All right. How long an adjournment did you need, Ms. Noveski?
Well, that might depend on the bond.
No.
All right, I guess it's time to put up or prepare to move out. She can discuss this with her client, but we're already lapping over into the next month. So I'm costing him another $800. What she wanted me to do was execute the writ of eviction immediately today and have the sheriff come put you out tomorrow. You have to pay the rent or move, and you want a payment plan, but he hasn't agreed to give you one. And you wrote a treatise of a letter, but that's really what it boils down to. You either need to pay the rent or move. Keystone was going to pay. You were going to get your tax return. You were going to get a job at Ox. The check's in the mail. I only had 2 beers. You know, he doesn't believe your representations because they haven't been borne out in the past.
I've never said check in the mail if there's not a check in the mail.
Oh, that's just a figure of speech. I'm sorry.
He is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today? Just gonna come out to court. Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today. That's
not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man. That's a wrong answer.
I'm sorry. I mean,
way the wrong answer.
I'm sorry, man.
I'll deal with this in a minute because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant's remanded. Take him. Court's going to stand in recess.
Yeah, may I, folks?
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
I gave him a false name.
What name did you give them, sir?
Mario Arredondo, just a friend of mine.
That's what you do to your friends?
I mean, it was a very terrible thing to do. I was afraid. I had a felony warrant at the time. Since I've gotten here, I've cleared it up and I've finished my time on that felony warrant. I just was assuming that as soon as I had police contact with the felony warrant, I was coming to jail. I was afraid, wasn't thinking correctly, and I made a bad choice.
So you made a selfish choice. So a friend of
Very
yours,
selfish.
you're going to use his name so he can make the fall for you, take the fall for you, so that you don't have to go to jail on a warrant because you failed to do something for probation.
No, there wasn't any crime I was charged with at first when I gave that name. They were just stopping because there was something that happened out of like the next city over. We were just literally, we walked a block and a half to the gas station and come home, and they stopped us in between that. So as they were questioning us about what happened, I told them we don't know. We just live on the street we were arrested on. We got arrested at the corner of our street. So there wasn't any charges to be had at that point. I just didn't want to come deal with the warrant. It was selfish. I'm very sorry about it. I learned my lesson from it and I won't make that mistake again. I need to own up for the choices that I make, and I'm doing so.
Well, Mario Arredondo is aware of what you did and is no longer friends with you.
I'm sorry, Mr. Taylor. If you have something to say that pertains to your case, I'd advise you not to say it. If it's something.
It doesn't pertain to my case, it pertains to the prosecution's case. She
Well,
also.
no, stop. The prosecution's case involves.
Okay, well, it pertains to the witness.
Then I don't want you to say anything on this record. I'll come and speak to you. The court has made its ruling.
Okay, but sir, you didn't inform them that she also has a letter that she went through the advocate in place with the court clerk as well as the prosecution that she will not be participating, that she has absolved herself of any responsibility where this is concerned. She's not going to testify.
Okay, Mr. Brown, first of all, and I'm just gonna just lay this out, and maybe Mr. Taylor, you should listen to your attorney.
Okay.
Because your attorney is telling you not to say anything to the court. Now you're talking about communications that you're aware of that have been made, or at least purported communications, where the alleged victim says now, unlike the affidavit in front of me, that she will not testify, which I don't know. And I'm not saying that you were interfering. It would be a little bit, I'm a little bit concerned that you know that.
You're right, the case was dismissed, but after it was dismissed, the prosecution brought the case back again. So it's not dismissed anymore.
But I've not stepped out of this one. They canceled it for 7 months. Is it right after they dismissed the case? They did not allow me to go out of the YJ County deal after they dismissed the case for 7 months since October. And if I need a lawyer, if you want to give me any lawyer on any case, I need a Republican lawyer. I don't want this lawyer. I need a Republican lawyer.
You need a what lawyer?
Republican lawyer. Republican.
A Republican lawyer.
I don't. Yes.
What does a Republican lawyer have to do with anything, sir?
Yes, it has to do.
I know she's not a Republican.
Because they kidnapped me. Yeah, this is kidnapping. This is kidnapping.
Okay.
Yes, after they dismissed the case, they did not allow me to step out of this YJ County jail. Is it lawful?
It is lawful, sir.
They're under different circumstances. And regrettably, Mr. Scott, we always end up back here. You were doing well for a while, and then we're back here again.
But I'm saying,
not doing it anymore.
Listen, can you listen to me, please? Can you at least?
I've listened to you,
Mr.
Scott.
This one chance I asked for, and I promise you, you won't regret it. Simpson, please. I got a lot of stuff.
Mr. Scott, I've given you at least 10 different chances.
I'm saying, can this be the last chance you give me, and I won't mess up?
That was what the last two were.
I know, but the last two you let me go. You said it wasn't my fault because the power was out, so that really didn't count as my last two. This is my time. I'm asking for it now. So please, can I get one more chance to go home and be on house confinement? I will not leave the house. I promise I will not leave the house. Please, I'm finna cry, bro. Like every time I ask for a chance, people give me a chance, but it's not willing to mind effect. I just want one more chance. If you give me this one chance, I promise I won't violate. I won't go out the house if you put me on house confinement. I want to be around my family. Just give me this one chance. If you give me this one last chance and I mess up, then it's meant for me to be locked up. But I just want one chance, just one more chance I ask for in life. And if I mess up, then it's meant for me to be locked up. But I don't want you to not.
That's what you told me the last couple times.
I know, but this is the last.
I made my ruling, Mr. Scott.
I know, but listen,
Mr. Scott.
Mr. Simpson, please, can you just
I made my ruling.
One time. I don't want to keep being in here.
Mr. Scott.
You don't understand me. My little sister died.
Yo, don't tell me that.
I'm saying.
Don't even try that, Mr. Scott.
But I'm being honest. What am I supposed to do if you don't want to give me one more chance in life? You think I want to keep staying being in here? I have.
Mr. Scott, time and time again, I've let you out.
All right, but
you want me to list them all? And some of them don't even apply to this case. And then what ends up happening? You end up back here. You keep saying you want one more time. I'm done right now.
All right, Mr.
That's
Simpson.
it. I've made my ruling.
Simpson,
That's it.
Listen, all right,
Mr. Scott.
How about this, Mr. Simpson?
Mr. Scott. I'm done.
Can I explain myself?
I have made my ruling.
It's being like
Mr. Scott.
I can't even.
That's it. I'm done. Cut him.
Did you not call your mom and ask her for permission? Your grandmother? Did you not call her and ask for permission? All right, so here's the thing. In this court, honesty is always the best policy. Do you understand?
Yes.
All right, so you're on probation. If you're not going to be honest, probation is not going to go well for you. And then what will end up happening, because this is a deferred case, and you're looking at 20 years in prison. Do you understand?
Yes, sir.
So here on out, I don't know what has happened in your life, up until now. Your attorney told me a little bit, but in this courtroom, you have to be honest. Do you understand? And, oh, why are you giving me the side eye? Stand up straight, stop tilting your head. This is very serious. I don't know what's been happening in your life. I don't know what happened with the discipline. Obviously, there are some issues because I understand that your mother is not in the picture. So what I'm telling you is you're 18. You're considered an adult. That's why you're in felony court. When somebody is placing you on probation, you need to be honest with them, because guess what? If I were to let this stand that you were to live with your mom, because you told me you were living with your mom, when probation would have gone out for a field visit, your mother would have told them she's not here and she's never been here. And guess what? They would have issued before me a motion to revoke. It would have been in proper order. I would have signed it. A warrant would have been issued for your arrest, and you would have been arrested wherever you were.
And has defense received those, or?
Yes, I do believe he has. He can correct me if I'm wrong, but if he has not received all of those, then.
I don't know what you mean by all. I have 2 police reports for these 2 cases. I received the first one after a case was filed. I received the second one after the case was filed, which I would add, I didn't even know there was a second file being opened until after I called and found out there was a warrant. So I don't know exactly what you're referring to, but if there is a specific email, I'm happy to look back at that. I'd never like to play, I don't play games. I just like to know what the details are. And in fairness, I try to do everything I can to keep everything above board. If there's something specific in reports, it's helpful for me to know exactly what she's pointing to, just like she wants.
Okay, then we can just ask the question. Is it something outside of the 2 police reports that he says?
Not at this time, Your Honor. And as for he didn't know there were new charges, if you recall a bench conference at our last meeting, I actually asked to adjourn because we were going to review something for pending charges. Mr. Feifelsky was standing right next to me when I told the court that. So as for games, I too do not play them.